First of all, I welcome everybody. I am Ramanuj from LawSikho, and thank you everybody for joining us today. I see right now around 116 people so far who have logged in. Many people have logged in into YouTube also, and many more are logging in as we speak. Every second we are having increasing number. I give the floor to Srividhya Ragavan, today's moderator, to take over the proceedings and let's begin. Thank you, ma'am.
Thank you very much, Ramanuj. It's a pleasure to be hosting this webinar on perspectives on legal education in a changing world. And I would like to invite each one of our speakers and thank you for giving us the time and thank you for agreeing to speak. Justice Bhat, Justice Sikri, Justice Sridevan, and President Young. It's a great pleasure. With that, I would like to start with Justice Bhat. I'm sure all of you know who Justice Bhat is. He's Justice of the Supreme Court of India and the author of the famous Roche v. Supla judgment, which reverberated across the developed world and today it remains one of the biggest cited judgments, even in the United States, on the question of patent linkage. So Justice Bhat went from the Delhi High Court to the Rajasthan High Court and got elevated to the Supreme Court of India. I welcome Justice Bhat to speak now, and he will talk about the opportunities in the bar and bench arising from global cooperation in the area of legal academia. So with that, I would like to...
He needs to be unmuted. I believe he's muted at the moment.
Thank you. Thank you, Justice Sikri, President Young, Professor Bobby, Justice Prabha Sridevan, and Dr. Ragavan. It's an immense pleasure and an honor to be asked to speak, going first, and that too in the side of Justice Sikri, who has been in many ways a role model, more than a colleague, has also been a role model. So it's an absolute delight. Increasingly in recent years, most graduates from law schools in India wish to pursue higher studies abroad. In the globalized world, with a complex web of laws and regulations applicable to different activities and across jurisdictions, and in the increasing application of international law, lawyers have much to gain from exposure to legal academia abroad. Graduate studies abroad give lawyers the opportunity to first learn about different legal regimes, to understand rules of evidence and show how they are applied in different jurisdictions, learn how courts function in those jurisdictions, interact with a diverse set of lawyers who have had their basic training in different and diverse legal systems across the world, build connections that can be valuable to legal practice, and engage in academic rigor, and have the opportunity to work with some of the foremost legal scholars. There is much to be gained from global cooperation and legal academia. Several students whom I have worked with and interacted with also prefer US and UK for graduate studies. These seem to be natural destinations for those who finish their studies or wish to pursue them in these countries. Being India being an English-speaking country in a sense. These universities typically offer a wide range of courses that students can opt in for across a diverse range of subjects. Students are able to apply law in a truly interdisciplinary manner, with access to courses as diverse as genetics and data science in combination with intellectual property law or privacy law. This especially is useful for lawyers looking to work in niche areas where scientific knowledge, for example, is necessary. For lawyers practicing in areas such as investment arbitration, treaty negotiation, international human rights, and humanitarian law also, exposure to legal academia abroad is important. There's one concern here which I would wish to flag, that access to such legal education for students and young lawyers from developing countries is extremely limited. Ivy League schools can be very selective, and the cost for legal education, especially in the US, is prohibitive. For the present academic year, overall costs at the top law schools are close to US dollars 90,000 for international students. Affordability, therefore, is a big barrier. All these opportunities to be gained are only available to those with the immense privilege of being able to afford graduate studies or who have managed to secure the few scholarships that are available. For those who cannot, regardless of their merit or brilliance, debt is a problem while getting back to the bar. This often means that lawyers who choose to study public law and aspire to work in areas such as civil liberties, public or social interest litigation, human rights, or even build a practice are forced to work in the private sector so as to be able to pay off education loans. Work opportunities abroad are also limited, and I suspect they'll start shrinking even further. And to make matters worse, visa restrictions are ever tightening for international scholars. Access to work opportunities could help immensely with gaining valuable practical experience that lawyers can then bring back to their own home countries and utilize at the bar and the bench. Harmonization, especially in trade law, arbitration, insolvency, intellectual property, and international taxation, affords lawyers splendid opportunities to gain from comparative studies in interpretation of common norms across several jurisdictions. Apart from benefiting immensely in their practical applications in international practice, these also afford invaluable insights into interpretation that can aid such lawyers in their home countries. Use of concepts developed in a particular country gain popular acceptance in jurisdictions and practice areas across several others. Examples are, and Dr. Srividhya Ragavan and Justice Prabha Sridevan would be aware, this practice of hot tubbing, which is recently developed in patent law, which has gained widespread acceptance across the world in expert evidence, especially in patent disputes. Other areas are use of common machine-assisted discovery methods, which can dramatically reduce litigation time. Growth and universal use of normative concepts and principles in international taxation, competition law, etc. A comparative perspective on the law and legal interpretation is not only useful but necessary for issues of constitutional law and adjudication pertaining to policy. Learnings from the criminal justice system in the US, for example, can be used to examine what systemic biases exist in the Indian legal system with respect to certain social groups. Empirical studies we have not undertaken, but I think these are all insights which we can greatly benefit. Global cooperation in legal academia is necessary for an exchange of ideas and developing legal solutions to problems that are common across jurisdictions. Another example is the equality jurisprudence developed by the South African Constitutional Court. In this era of Anthropocene, issues arising from human activity are at the forefront. To take a topical example, police brutality and high levels of incarceration for some communities are problems that legal systems across the world grapple with in different degrees. Environmental harm and affixing responsibilities for environmental tort is another. The emerging interface between biotechnology, artificial intelligence, and the challenges which humankind faces in the form of drawing up acceptable limits and ethical standards within which these developments can be assimilated commercially are common to all societies. Ensuring equitable access to resources, especially to the marginalized sections of all societies, articulating emerging rights in the digital sphere, ensuring access to information in the internet era, access to healthcare. These are all issues that lawyers and courts across the world commonly deal with. It is now the time for global cooperation and collaboration in developing jurisprudence. I believe, therefore, that access to legal education abroad and exchange of perspectives is very useful with the pandemic of affecting high-income countries as well as developing and least developed countries alike. It has become possible to exchange information in new and innovative ways. Education has moved online in most places. This means that with minimal expenditure, global cooperation is possible. I think we are now at a cusp of in our social development where societies may have to seriously redefine education, at least in some areas, not in content, but in the going back and examining the delivery mechanisms which have been traditionally resorted to. It is time that faculties at law schools in other nations, including the US, collaborate with Indian law schools to teach interdisciplinary courses and vice versa. The focus needs to shift away from formal graduate studies as the only way to gain international exposure, as this route is closed off to many who cannot afford it. With greater accessibility and collaboration comes the possibility of a more just world and a greater, number of brighter graduate students emerging and helping their own countries and the international community.
Justice Bhat. I now invite Justice Sikri to talk about the changing role of the legal industry and how academia can adapt to play a bigger role. Again, Justice Sikri needs no introduction. He recently retired as the senior most justice of the Supreme Court of India. He currently serves as the international judge at the Singapore International Commercial Court. Justice Sikri is, of course, well known across the globe, and he's also the chairperson of News Broadcasting Standards Authority. I invite Justice Sikri to talk about the changing role of the legal industry and how academia can adapt accordingly. Thank you.
Good evening from India and good morning from US to all of you who are listening here, including my panelist, my esteemed younger brother, Mr. Justice Ravindra Bhat, my elder sister, Prabha Sridevan, and Justice Robert, Mr. Young, and all other who are this and who have joined this program. Actually, this Justice Bhatt has already laid the foundation, if I may say so, insofar as the question which you are asking me and for answering that question. I would like to, sir, just summarize in my way, or rather put it in my way, what Justice Bhatt has said, and then on that basis, what is the role of legal industry today, and how academia can adapt to a bigger role. That is a question which you asked me. Now, I'll say it in an Indian context and then in the larger global context as well. You see, in India, as when the Britishers came, and today we are in this common law system which we have inherited, like which is the system in your America as well. It started in 1800, so early 19th century or late 18th century. So therefore, entire edifice is built on that common law system and the laws which were passed during that time. The second phase comes when, and the changes which took place when we got independence. With the independence, the major, turnaround was that we gave ourselves a constitution of India, like in America, American constitution is there. So it paved way for not only the ordinary kind of litigation between the parties, but about the social justice and human rights, liberty of persons, etc. So those all things are also there, which the judiciary is supposed to do, which the lawyers are supposed to argue before the courts. And thereafter, I would say immediately though India started on the path of industrialization after independence, and that was the policy of the government, and that again gave rise to passing of so many laws in a commercial and industrial field, etc. And more importantly, in early 90s, 1991 or so, when we entered the era of globalization, and so that was with globalization, this came now cooperation among the countries, and because globalization with it brought not only the movement of capital from one country to other, and but the movement of human resources as well. Like I can see there are so many students, our Indian human resource, which is sitting in US, and are now listening to this webinar, and it has taken place in so number of ways. So what was the important thing at the world level which happened now because of this globalization and liberalization was convergence of the so many issues, or so many laws, I would say. Up to now, those particular laws which were, I mean, the problems which were arising and which were discussed by the courts at domestic level, they became international. They were internationalized. As Justice Bhat has said, you talk of arbitration law. So we used to have before that cases, most of the cases, I would say, not all, but 80 to 90% cases only domestic arbitration, because they used to deal with domestic laws, but now international arbitration started. International issues in intellectual property started because of movement of capital and technical know-how, etc. And international taxation, as Justice Bhatt mentioned, antitrust laws, again international ramification, competition laws, etc., insolvency laws, and then private international law, conflict of law, even the family issues because of the movement of, as I said, human resources. So those issues have started. He's talking, and even the human rights have taken the dimension of universalization of human rights have taken place. Whether you talk about privacy, you talk of health, which again Justice Bhatt mentioned, and even you talk of the issues of identity and dignity, which even today America in the present regime is talking about so many such issues, and India also. So therefore, all these areas have become now totally international. So all this has contributed to, in a way, a total paradigm shift insofar as role of legal industry is concerned, because that is the first thing which you are saying. So today, role, and coupled with that, I should add here now, which we are seeing in much more force because of COVID, that is the introduction of technology. After globalization, this is, I will say, another field, that is technology, artificial intelligence, and computerization, which has come, I mean, in a big way, but which has now shown its, I mean, in a way that we can't do without it, its indispensableness in COVID times, when we are depending on technology to large extent, even in legal practice. So therefore, as far as role of legal industry is concerned, now this, because of all these reasons, it is changing. As Justice Bhatt also pointed out that, of course, that was in the context that all this can be, how it can be taught by and how we learn from the universities abroad, and when the students are, I mean, getting this kind of education. But why that has become necessary, and the role of academia comes there. And so today, I would say the practice may be at two levels. One is where we talk of constitution and constitutionalism, fundamental rights, social justice, etc. That is one. That may have domestic, I mean, ramification. That may have international ramification. When we talk of immigration laws, etc., they are human rights issue, but of international ramifications. That is one aspect. And other aspect is when we talk of all these convergence of laws, where uniform laws, UNCITRAL is coming out with, on that basis, all countries are enacting the laws on uniform basis, and all these issues which are having now international ramifications. So they has changed the area of practice also. That today a lawyer doesn't remain only a lawyer in his or her country, but we need to have international lawyers who not only should know what is happening in the world, but they should have 360-degree views of the issues so that they are able to. Justice Bhat would, again, I am quoting him, he would vouch for this. In last, I remember 2 or 3 years of my Supreme Court judgeship, when I was sitting on the Constitution bench and hearing the matters like this issue of privacy, those judgments came, and other euthanasia, etc. And the law from all the countries was cited before us. So therefore, this comparative constitutionalism and all those aspects are today considered with open heart and open mind by the Indian Supreme Court. And so therefore, that is one part. Other part is, as I said, that when this IPR, arbitration law, investment treaties, this insolvencies, antitrust law, all these are giving different kind of color insofar as practice is concerned. Today, lawyers don't remain in one part of the world and practice there. They are all roaming about. That is one. And another thing which I said is contributed is artificial intelligence, which has today changed total perspective, and more particularly, it has not been felt to that extent in India. But I know in US, today there's so much reliance on artificial intelligence that the scope and even the contour of practice in US have changed. The clients have become now is trying to control the process. It is not that clients are going to the law firms for all their problems initially. They may rely upon artificial intelligence more or other technology more. Today a person has this is a tendency that I'll go to Google and try to solve my problem if I can get the answer, and go to lawyer later on. And with now there was one study also conducted by if I say so, it is called Center on Ethics and the Legal Profession at Georgetown University Law Center. And they came out with the very interesting, revelations. They said that the key trends include the changing role of clients, emergence of non-law firm legal competition. They are the non-law firms are now competing a lot. Then they are more, and that is forcing law firms to come out with more innovative ways to show their worth. And in the process, what is happening today is that the way practices are to be done and the way the lawyers are to be trained, because of all these reasons, cumulative reasons, it is changing. So keeping in view all these aspects in mind, the second part of the question which you asked is that how legal academia can adapt to play a bigger role. So therefore today, the academia or the universities don't have to produce by giving traditional knowledge in law to the students. And yes, this is what the contract law is. This is what the intellectual property law, trademark law is. This is what the private international law is, or public international law is, the textbook law. It is not confined to that. Today, they can play a much, much bigger role in shaping their students to meet the challenges which a student, when he turns a lawyer. And another very important thing is that this kind of role of legal industry is again giving so many making so many avenues open for the students. It is not necessary that they have to come in the field and have to become litigating lawyer. They can be litigating lawyer, they can be corporate lawyer, they can be in-house counsel. Apart from, yes, like you, they can be teachers. So there's so many areas which are open. And according to me, and we can develop on this later during discussion, that legal academia can adopt this bigger role for training the students at that level by giving them clinical education, by imbibing more skills in them to meet these challenges when they come to the market. This is what I will say.
Thank you very much, Justice Sikri. And now to Justice Prabha Sridevan, a dear friend, a mentor, and someone with whom I've had several arguments on IP policies. Justice Prabha Sridevan comes from, was a judge in the Chennai High Court. She's very well known for several things, but for me, the Novartis and the Bayer judgment stands out. Both of these judgments have had international impact, and both have affected access to medication. Other than that, she's an artist. She writes in Tamil. Some of her Tamil translation books have won awards. And the other important aspect is she's a wonderful feminist judge. She's given wonderful feminist judgments. Some of her judgments on the issue has absolutely changed the discussions involving women. So I welcome Justice Prabha Sridevan, and she will talk about how legal education can be more inclusive. With that,
of health and safety to all, whichever time zone you may be. I'm very, very honored to be here along with Justice Bhat, Justice Sikri, and President Young. And I'm very grateful to Mr. Ahdieh and Professor Ragavan for including me in this panel. It's really an honor to talk about inclusiveness, the importance of inclusiveness in legal education in the changing time. The inclusion of different groups in legal education has been historically very low. Is it improving? Yes, it is improving, but not at the rate that we would like it to. Will inclusiveness have a ripple effect of impact exponentially is something that I don't have a data, but I do believe that there must be inclusiveness. Now, this virus, which is threatening the whole world, they say after, if there is a post-COVID world, there is going to be a new normal. Is that normal? Will that normal be something from lessons learned or from lessons unlearned is something we'll have to find out. But definitely we need wise judges and wise lawyers to guide us through the new normal life. And I will give you the names of 4 extraordinarily wise lawyers whose vision of equality was unparalleled and whose vision of fraternity was deep. They are, and I'm telling the names in chronological order, President Lincoln, Mahatma Gandhi, Dr. Ambedkar, who is the father of our constitution, and Mr. Mandela. They really transformed the world that they saw it in a transcendental way. A great list, right? But there is something wrong with it. What is it? There is no woman. And why? Because at that time, women did not have that access to legal education that they should. And when I talk of inclusiveness, I am going to focus on only this group, the woman group, and what I say will apply to any group that is disadvantaged and which has not had the benefit of accessing education that it should. Will the inclusion of women, will the access to education for women have changed the list of 4 that I gave? I'm not sure, but definitely the experiences of women and any diverse group that you may think of will bring a depth and value to legal education, advocacy, and jurisprudence that is really necessary. In his extraordinary book, The Strange Alchemy of Law and Life by Justice Albie Sachs, he speaks of 4 kinds of truth. And he speaks of Gandhiji's experiential truth. And this is what he says. It is the understanding gained from being inside and part of a phenomenon. I am black. I am Dalit. I cannot see. I am a woman. These are all part of being a phenomenon, and I have the experience of being that. A non-black can perhaps approximately understand what it is to be one, but definitely will not know what it is to be a black unless one is that. And that experience will definitely translate into life itself if that experience has access to legal education. The knowledge gets translated not just into political, social, and economical spheres, and I dare say religious spheres too. And this transforms the structures, the internal spaces. And not just the internal spaces you'll be interested to know. Even external structures like concrete buildings get changed, get altered when diverse groups enter the portals of education and legal education. This is something that I heard at an interview by Baroness Ale. It seems when she became a judge for the first time, they had to build a women's room in the Supreme Court building. Because women, they never thought women would enter those hallowed spaces, right? But women did. Baroness Hale did, and we will. We must. We must enter those spaces. And therefore, changes, sweeping changes will come not just into the external spaces, but the internal spaces as well. And admission policies should be inclusive. I truly believe that Justice Sotomayor's dissent will appeal to the intelligence of a future day which is not too far away, but soon. It is a kind of a politico-social arrogance to fashion a policy that is facially neutral, but does not accommodate for the different groups positioned at different distances from the line of equality. It's not enough to say it's there, you can all reach it, because each one comes from a different distance because of the historical and other disadvantages. A facially neutral policy that does not accommodate for it is almost Marie Antoinette-like in its arrogance. Yeah, it's an apocryphal story, but it serves the purpose. And I must stretch this a little more. The policy makers must accommodate for the financial requirements if need be, because inclusiveness is very important. I paraphrase Professor Sandel's remark. I would say that inclusiveness is not merely weighing costs and benefits. It is a moral duty and a human right so fundamental that they rise above such calculations. Inclusiveness is incumbent upon all those who are in charge of legal education. And now I will give you a personal story. Srividhya spoke about the judgment which said that women's work at home must be given an economic value. This judgment I had the opportunity to author when I was in the Madras High Court. There was a young girl who lost her mother, and we had to calculate the compensation that the child should get for the loss of the mother. If the mother is a homemaker and does not work outside, there is a calculation which treats her as a non-working person. And it is a nominal amount that the person deprived of the mother will get. We decided that we were not non-working and we did not deserve just a nominal amount if we died. Yes, everybody who works at home, I think works, there is no retirement and there is no hours of work. And therefore, we said that this work at home should be assigned an economic value. After the judgment came, 3 of my colleagues, all men, called me and said, "We totally agree with you, Prabha, but I don't know why we never thought of giving the judgment." The judgment had after that been affirmed by the Supreme Court. So now all the courts in India, it has very heavy precedential value. why did the three men who agreed with me not translate it into a judgment? Because for me, I know what it is to work at home. And it is that value that inclusiveness will bring to jurisprudence and advocacy if the access to legal education is made more inclusive. This is what Gandhiji calls the experiential truth. Many changes have happened to us. Many changes are happening. We really don't know how the world will change. There are incidents happening in your country and mine. You have the protests. We have the long non-state workers walking to home after this lockdown. How will their rights be decided? Who owes the duty? Are all interesting questions that have to be decided. And if the admission policy allows inclusion from an almost monolithic group, the vision will be narrow and the structure will be poorer. I don't think we can afford to do that. We have to include as much diversity into legal education as possible so that it will set right a lot of the demand for rights that the times to come will give rise to. And who will be richer for it? It will be we the people. Thank you.
Thank you, Justice Sridevan. Inclusiveness, of course, is the cornerstone of what we are doing, both in the United States and in India. So we take the message of inclusiveness very, very seriously. With that, I want to introduce President Young and invite him to speak. I want to say something. In 2004, I joined the George Washington University School of Law. At that time, my PhD supervisor talked about the then dean and said how wonderful he was. But I joined and he left, right? And then he became the president of University of Washington and then Utah, and several years passed by. About 5 years back, I called Marty Edelman, who was my supervisor, and I said, I'm thinking of moving to Texas A&M as a faculty. And the first thing he said was, you're finally catching up with Mike, right? So that was his word. So it's an honor to now be at Texas A&M and yes, finally to be working under you, President Young. President Young, of course, has instituted several changes, impactful changes, and serves as the president of Texas A&M, which is one of the biggest schools, I want to say globally, but definitely in the United States, inviting you to speak on the future of legal education, sir. Thank you.
Sri, thank you so much. In fact, I've been trying to catch up with you for the last years. It is a pleasure to be here. I am honored to be on this panel. Thank you. It has been extraordinarily informative, and I have taken about 6 pages of notes. So I know how much I have learned and how much I appreciate this. I think it's particularly useful to have this kind of a conversation as well. I don't think there are any two countries in the world that are more committed to the rule of law, more committed to the notion of justice. As much as we both struggle, I think it is so core to the being of both of our countries, more than I think really almost any other countries in the world. It really does make it a pleasure to talk about these critical issues together. Thank you. I am intrigued by the fact I'm going to talk about the really 4 themes very quickly, each of which I think has been talked about already eloquently and insightfully. So I am particularly struck by how complementary our concerns are about both the legal profession and legal education, generally speaking. And I will just touch on each of these briefly, but it really, the first deals with the issue of technology and the transformation that is changing, as well as the opportunities that's providing us. The second theme really has to do with the expansion of education, particularly legal education, beyond the technical issues of legal interpretation of laws and so forth. The third really has to do with that issue of opportunity, of access, and the fourth is cost. So let me just touch on each of those briefly. We are seeing, in light of the pandemic that's sweeping the United States and certainly much of the world, a tremendous acceleration in the use of technology in our classrooms, which gives us some opportunity to think about, as we come out of this pandemic, what have we learned and how can this transform? And I know this is a constant conversation around our university and around universities throughout the United States. It will enable us to do a number of things, some of which have been touched on already. We'll be able to reach broader audiences, people who may not be able to come in a traditional educational setting, but be able to still nevertheless take advantage of the content that these great universities offer. It will also, I think, over time, and this relates, I think, to Justice Sikri's conversation about the changes in the legal profession. I think one of the things we will begin to see increasingly is some disaggregation of the legal profession, where you have people who may be benefited by the kinds of legal education we have traditionally offered, and others who could do important legal functions but at a more streamlined after a more streamlined educational experience and at far less cost, and become more efficient and more effective. Be able to reach out to non-traditional students, to many students who are otherwise place-bound more than they have historically been, and be able to think beyond that distinction we have generally thought about between skills and sort of intellectual training, and be able to find ways to meld those in powerful ways, I think. But I also think, and particularly important for today's conversation, and Justice Bhat, I think this really follows on what you said so eloquently, is that we live in a global world. And it is, we are in the United States among the most cloistered and least likely country to look abroad or to think about what we learn from foreign legal systems and how we interact effectively with foreign legal systems. And I've spent much of my career dealing with international trade, international human rights, and other international related issues. And I see that on a daily basis. I think technology may provide us an opportunity to think about expanding the capacity for universities across the world to cooperate, where we're able to do classes together, even though the students may remain in their home countries, where we can think about virtual internships. We can think about ways in which we can use different kinds of partnerships that would really allow us to expand international education, make it a central part, not a peripheral part of what we do in American legal education and American education more broadly. Our university sends more students abroad for study abroad than any other university in the United States. It is still probably no higher than 5% of my student population. If I could use technology in a way to give everybody a virtual student study abroad experience, a virtual experience to take a class at one of your great universities and the like, there are really possibilities there, I think, that we just have not even thought about. I think the other thing that it will enable us to do over time is to think about more opportunities for lifelong learning. We're able to, as we see the legal profession transition, provide education that really fits that transitional phase that occurs. I used to ask, when I was dean of a law school and when I was teaching at Columbia University, would ask alumni, how many of you are practicing in a field that existed when you were in law school? And half the time, the alumni would raise their hands saying they're not even practicing in a field that was even a field when they were in law school. So I think this will give us a chance to build on that rather dramatically. And then that really segues into the second issue, which is the opportunity for cross-disciplinary work. We are seeing increasingly, having followed a very sort of Bismarckian or Prussian model of education where the disciplines are very siloed in the United States, increasingly realizing that while the advancement of those disciplines has been aided dramatically by that kind of siloing and that sequestering of the disciplines together as a structural matter within our universities, increasingly we see the tremendous interconnections. And that is tremendously true in law as well, where we see that law professors, if you're going to do intellectual property law, you really have to have a certain kind of technological understanding. To the extent you are thinking about human rights law, about justice, understanding of sort of basic social structures within the society become absolutely critical. If you're doing criminal law, the psychological dimensions of behavior become very important. One can go on and on about these needs for our lawyers to have really enhanced disciplinary background. But the same is true in reverse. If you look at a hospital administrator in the United States, for example, that person may be looking at the hospital from a business perspective, but probably half of what they do really involves compliance issues, involves legal structures. And so being able to introduce others who don't necessarily have or require a legal degree, the opportunity to have some enhanced understanding of the legal in which they're operating and being able to operate more effectively with their lawyers and within that context gives us, I think, tremendous opportunities. And I think technology can aid that rather dramatically, but I think technology or not, that's a direction in which education, generally speaking, and legal education in the United States, we see very much moving. I go to the issue that was so wonderfully articulated by you, Justice Srividhya. It was, we see a situation in the United States where we have had differential access to education across the board. There have been historically underserved students, students who may be first-generation students, students who come from communities, from racial backgrounds, ethnic backgrounds, where the financial and other challenges for quality education to allow them to really realize their full potential has been limited. That is something that is increasingly apparent, and the need to rectify that absolutely clear in a whole variety of ways. And I can go through the litany of things that are being done, none of which are fully successful yet, all of which really need that focus. And you give a beautiful reason why that is essential. In the legal profession, understanding the perspective of a broad variety of people helps us develop a system that is more just, equitable, humane, in a way that it absolutely needs to be. But I would also add a very practical dimension as well. As we send our students out into the United States and the world to work, they are going to work with people from very different backgrounds. If they have not learned how to get the best out of everybody, they are really not going to be successful. And then thirdly, I would add that perspective becomes important across the board. And that talent becomes across the board. You talk about excluding women from various jobs in the workforce historically. I don't care how rich your country is. You cannot afford to waste half of your resources. No country can survive by wasting half of their resources and not taking advantage of half their resources. I couldn't, if I squandered half of my money every paycheck, I would be in a very difficult situation. And providing opportunity to ensure that everybody has the chance to reach their full potential is something that's become an enormous focus for very ethical, moral, powerful reasons related to justice, but also very, very practical, pragmatic reasons to the benefit of all of us. And then I finally end up on the issue of cost. There is a great deal of debate in the United States about the cost of education, whether the return on investment is really worth it. We see that in the legal profession very, very clearly. Universities I have taught at before, Columbia, George Washington, you're seeing tuition upwards of $60,000 and $70,000. That only makes it difficult for any foreign student to have an opportunity to study in the United States. It makes it very difficult for broad swaths of American students to do that as well. We have to think through and have to find a way to surmount this rising cost issue. Part of it is a result of the increasing cost of what we're doing, but part of it is a cost of increasing disinvestment on the part of the nation and the states in education, both of which are serious, serious problems being addressed in the United States. Again, going back to where I started, I think technology may have some advantages in allowing us to increase our efficiency while not reducing our effectiveness. And so I think we're going to see some significant changes which are being wrestled with, I think, as we speak. The challenges are real, but the opportunities, I think, are really quite extraordinary. I think we're at an inflection point where we really have a chance to do some transformative work that really does change what we do in legal education, change what we do in education more broadly, in touching on the themes that each of you have raised as so critical and so important. So with that, thank you very much for allowing me to participate. It has been enormously interesting and helpful. Thank you.
Thank you, President Young, and thank you, everybody. I want to highlight that we have 270 participants at this time in the webinar. So I've received several chats and several questions from people who are participating. Now, but I want to pick one which relates to inclusiveness, and then we'll go to some of the other questions. The first of those is for me to react on the question of inclusiveness. How do we decide? How do we move forward with the question of inclusiveness? I want to highlight right now there are protests in the United States because of I want to say lack of inclusiveness. This forum, LawSikho, has had some issues because of lack of inclusiveness. You know, one related to women, the other relates to race. And I'm pretty sure every country faces these questions, every company, every person, we all face these questions of bias, both explicit and inherent. What do we do to move forward is how I look at it. I spent much of yesterday actually looking at some of the apologies that was posted by LawSikho. To me, inclusiveness does not always, I mean, for some people it comes naturally, for some people it is acquired. The idea is to help people acquire inclusiveness and to open their eyes to be inclusive in several ways. So for instance, with LawSikho, I had a conversation last night, once I read through some of the apologies to see how the forum can be more inclusive, more accommodating, more inclusive of women, and celebrate what women have done as a means to, possibly bring more women into the forum. The question about women and LawSikho, of course, came in the context of some of the issues they faced. We face the same issues with reference to the lack of inclusiveness in the United States. How do we have forums? In fact, the Ahdieh is going to hold a Zoom session on Monday. Am I right, Bobby? On Monday, to talk about inclusiveness and how we can be more inclusive and how we can listen to diverse voices on Monday. So the question always is how we can move forward, how we can move forward in a way that we educate on inclusiveness and deal with it in a way that some of the, that we address some of the issues that have come up in the past. Am I right, Justice Ravindra?
Yeah, I agree. And this is something that I would like to add. I think LawSikho said that they did not really anticipate something like this. They were taken aback. But how I reacted to it is, it's very easy to trivialize language and a situation, and it is only the discriminated who understand how it feels. So you can't be doubly cautious. You can't be too cautious. You have to learn that and unlearn wrong language and unlearn wrong attitude as well.
Absolutely.
So
the question,
if the apologies mean it's a lesson learned, then that's good.
Thank you very much. With that, I want to go to the next question, which is a question from Minaj. The question is, given the private universities have in India at least, are tied to many, many regulations, should there be more dynamism in public universities such that they bring more opportunities for education, etc.? So can we expect a reaction from one of the speakers? Should public universities take a more forefront approach, and should they, should they work to bring in more opportunities?
Yes. Justice Bhat, you will answer. Should I? Please, you answer.
I don't understand the question. Is it in the context of universities in India or in the US?
In India. In India. Yeah.
In India.
Yeah.
Well, I think. I mean, I don't know what is meant by a lot of restrictions. The restrictions in private universities. There is a great deal of autonomy in private universities, and many of them, without naming, I do not wish to name any, but they have a lot of interdisciplinary approaches. And in public universities in India, I can vouch for, say, the Campus Law Center, where I studied from, that even Justice Sikri graduated from, and some of the national law universities. There is a greater awareness about the nature of curriculum, especially in the national law schools. You need to, but perhaps there's more work needs to be done on the linkages between the humanities, the liberal arts and law, and in some cases I would say science and law. And when we speak of law and legal practice, it's very important to understand social needs, and there has to be not just a sociological or a political content to the pedagogy, but I think there is a great need to understand the psychological aspect. So, strong base in anthropology, sociology, and psychology needs to be, and of course you have philosophy in the sense of jurisprudence, but how it relates to contemporary society is a very important aspect, because at the end of it all, the legal profession is not geared to produce only corporate lawyers. It is meant to address social needs, where we are all talking of inclusiveness, we are talking of gender issues, we're talking of people who are completely marginalized, who are virtually out of sight, and whose needs are unmet. So how do you draw the attention of people in these law schools, many of whom may come from very privileged backgrounds, not necessarily all, and even the others may not be focused on these. So I think it's important to allow these kind of linkages in interdisciplinary some kind of pedagogy is required. I would certainly say that there is a great need for that, even in public universities. It's not that what is there in private universities in India is sufficient. There may be in some, but I'm sure this is a case where we do need more.
Thank you. I want to, the next question is whether it's advisable to acquire an LLM through an online forum or a distance education methodology from a foreign university, and what are the benefits of that? So I want to get reactions on that. President, yeah?
I think.
Well, I would be happy to just say a word or two about that. There's certainly something very advantageous to an in-person study, particularly on the international side, because you have a tendency to learn as much outside the classroom as you do inside the classroom. The capacity to interact. I've studied abroad at foreign universities and be able to understand the context, the mindset, and so forth of those with whom you're studying and from whom you're studying is very, very powerful. And so I would not say that a online LLM is a substitute for that on the one hand. On the other hand, I would say, nevertheless, depending on what skills one needs and what one wants, it can be extraordinarily useful. And sometimes it is, one must not let the enemy of the best become the enemy of the good. And if an in-person is not possible, nevertheless, I would not abandon the quest for an LLM at a foreign university. But if it's available online and that is the best alternative given one's personal circumstances, absolutely worth it in my judgment. Particularly if you get it from Texas A&M, but generally speaking, probably.
Thank you.
No, if I may add to that, actually, you see, this LLM, when we talk, we are talking of post-graduation in law. And therefore, this persons or the students who are going to join that, basic law, graduation. And therefore, I think, and particularly now COVID-19 situation has made us realize the importance of technology and online education. There is no harm. And I would say that rather it should be an opportunity which should be welcomed by the universities by offering the LLM or higher studies, these degrees online. And as I know in India, we have one private university, OP Jindal Law School or University. It has already started. I think it is going to be either today or tomorrow, or it has happened yesterday in one of these days, the inauguration of that LLM online. So therefore, it's a brilliant idea, I would say, which should be experimented.
I agree. And if I may add one other small point, which is we tend to think of all or nothing. That's either online or in person. But one of the things we're discovering now is that you can actually, there's some very effective ways that online can be as good or superior to in person in terms of knowledge conveyance and information conveyance and so forth, which doesn't preclude you from coming to the university perhaps for a summer program where you do get some different kind of in-person contact, or coming for a month, or having the foreign university send some professors to the foreign country, the American university send some professors to the foreign country to do some instruction. So thinking of some hybrid model where you get the best of both worlds is also.
There I agree. I'm not sure it's continuation of this physical form of education. Yes, it has to be a hybrid model. Yeah.
In fact, this is what I had in mind when in the last part of my remarks I had said that we need to go back to the drawing board and redefine the methodology, that is the delivery content, is the delivery mechanism. So this is what I meant, that maybe it's time that we look at not students coming from developing countries to the United States or these foreign universities, but these lecturers and professors coming and teaching during specific terms, or taking certain courses, a capsule course or something like that. Because ultimately, when we talk of liberal arts and law, there is always a context, even at the postgraduate level. And of course, speaking in favor of online teaching, it is to be said in its favor that apart from the classroom experience, there is always this you can always resort to audiovisual aids, especially in technology and certain areas, which would be very powerful in terms of the teaching.
Absolutely. Thank you, sir. I want to ask, we've been working with Dean Ahdieh to consider online programs. So I want to ask Bobby to just say a couple of words about some of the things we are working on, and they fit perfectly within the framework of what each one of you have said. And so, Bobby, would you care to react for like a couple of seconds on this?
I'll be very brief because I really mostly want to hear from others. And hear the responses to the questions. So I'll just say again, from my vantage, and I had the pleasure of being with a number of the justices, and I look forward, Justice Srividhya, next visit to see you in January. I'll say that again, the opportunities from my vantage for India and the United States to learn from one another in general, but particularly at this moment, are, I believe, truly extraordinary. Some of that has to do with geopolitics, frankly. Some of it has to do with, our nature as these two very largest in the world democracies. Some of it has to do with sort of the shared common law, rule of law tradition. Very different, obviously, trajectories we've taken, but that common root, I think, creates tremendous opportunities for learning across that divide. As we were getting ready in January, Professor Ragavan and I, to travel to India for 10 days that we were there, I was doing some reading also about the amount of interaction of all sorts. Texas, I had not known this, has among the largest Indian expatriate communities in the world. And not just in one place, both in Houston and in Dallas-Fort Worth, we have very large Indian communities. So that is an incredible starting point, obviously. It's also the case that sort of lots and lots of Indian companies have set their U.S. headquarters in India, their U.S. headquarters in Texas. And the amount of the volume of trade and the volume of interaction is tremendous. So I believe Texas is the largest single state in terms of trade and interaction, the foreign direct investment, the like with India. So that creates a setting in which we as a law school, and I think we as a university, as President Young has suggested, really want to identify the opportunities for all the sorts of interaction we've talked about. So where there is the opportunity for someone to be present, either our faculty to be present in India, or lawyers and law students to be present for a time, a week or two, a month, or two in the other country, wonderful. Likewise, if we have programs that are creative, to some of what Justice Bhat was saying, creative ways to collaborate. So we are talking to a number of law schools in India about programs where the course of study would begin in India and then carry over to the United States, carry over to Texas A&M. And the notion is there are folks who may not have the luxury of being able to be away from India for a year, but could be away for a semester. We're talking about other programs, one that we hope to manage, which will have a significant online component, but for those students who are interested will include, as President Young described earlier, the opportunity to come and spend a month during that course of study doing research in residence, which creates those opportunities. So I think the big things I would sort of contribute to say that I think this relationship, there is tremendous amount that as lawyers, as law professors, we can learn from one another between India and the United States. And that if we are creative about how we structure the programs, I hope that we can expand significantly the audience of both folks on the Indian side and the US side who are able to capitalize on those programs. Is that my chart, Mr. Ragavan? She's my boss.
Sure. Thanks, Bobby. So we go to the next question, which is what areas do we think is appropriate or in which the quality of legal education should improve? And should we also need more sort of practical training for Indian lawyers? Those are the two components, and actually from two people, but I thought both were related that I could add them together.
Right. Yeah. Say in the meantime something.
Please, Justice Sikri.
Sir.
Yeah. Okay. I think Justice Bhat is now unmuted. If he wants to speak, he can speak.
No. You say you Justice Sikri. You
no.
can.
What actually I tell you, I would say I would take it at 2-3 levels, or put it in 2-3 buckets. This thing. One is the teaching method itself, which I feel in most of the American universities, it is. What I want to say is that they are already practicing that is Socrates method, and the more of discussion in the class where the students come after reading what is to be done, and then that is discussed, which I feel that should be emulated in Indian universities also. Of course, in Delhi University, from where I graduated, we introduced a case law method whereby the cases, the actual cases, the decisions of the courts are studied, and then on that basis there are discussions, which is again good. Apart from that, this is all the theoretical level of, education. But then, as we discussed, the demands of the legal profession today and the legal world, going by that, yes, much emphasis should be on the active teaching methods, active in inverted commas, which will include clinical work, etc., and the placement of the students with the lawyers, with the judges, taking them to courts so that they witness what is happening, the placement with the law firms, etc., how they work, how they function, that practical training they get. And another thing which we have already discussed is that new sophisticated courses that dealing with the various aspects of law and which developments which have been taking place. But then, in addition, as to what is happening, I think at the level of this education itself, and the universities can take care of this aspect also, that how to use technology, say artificial intelligence, etc., because the students now, when they go to practice whichever field they go into, as I said, so many fields now, this when this is a technology of the present, and it would be needed to them, why not they have these facilities in the law schools also. And so therefore, these are some of the ideas which are coming in my mind, by way which the students can be, given more practical training. But it will depend then at what stage it is. It would be at more at the graduation stage. When it comes to LLM, etc., then some of these things may not be required, but because the purpose of doing higher education by the LLM students is totally different. This is what and Justice Bhat can add to what I have said.
I just want to say this, that about at the graduate level, I totally agree that there is to be a lot of clinical, and there has to be exposure to practical learning. I'm not so sure about artificial intelligence, because these are tools. Now, these are tools which eventually those who get into the profession will pick up, especially whether if they enter into the corporate practice, it's going to be part of their training. And if they enter big ticket litigation, that too they will get to learn it. I don't think this area of learning is as essential. But according to me, there is one area which at least some topics and some subjects in management, especially in I'm speaking from the context of an Indian judge who has been an Indian lawyer. Your time management, you're managing your own docket, your own small office, how you have to, the workflow in your office, workflow in the court. These are very essential learnings which people learn through trial and error, depending on which kind of office they work in. So that is one thing which I think has to be taught. And coming to clinical exposure of clinical, teaching, I think it's absolutely essential when we are talking of marginalization and inclusion, and we talk of huge swathes of people. It is important that the legal clinics and the kind of projects which are given are compulsorily focused on some of these areas, at least during each year of law teaching, law school, in some form or the other. As I said, the aim of law is to serve society. And if you don't understand the people whom you are going to support, just supporting some entity who is a corporate or a juristic entity, and turning out to be someone who is assisting in its profits, takes the soul out of you. So I think it's important to emphasize this, and the best time to do so is done at the graduate level.
Thank you. There was a question again on defining inclusiveness. How do we move forward when there has been a situation where we perceive a certain level of lack of inclusiveness? What is the best way forward? And this person wants a little bit of my reaction, and of course from the justices as well, and from President Young as well. So I believe, there can be situations like that, and the idea is not to crucify them for their mistakes, but to help them make amends, and to especially when they're trying to make amends, are they apologizing? Have they apologized appropriately? And are they making appropriate amends to ensure that the excluded set of people are actually included more? So that usually is the way forward. So we always look at how do we move it forward to the next level. So with that, I want to open that question to Justice Sridevan again, and then we'll go to the next question.
I spoke of admission policy being facially neutral, but if you notice, even laws, though seemingly neutral, do not fall evenly. And I am also posing a question to all of you. Law making itself should, because traditionally it has been, lawmaking has been in the hands of men, traditionally for a long, long time. And that continues, that structure, that psychology in the law continues. So is there a way of changing it? I particularly like what Justice Bhat said about including humanities. That is a way to I think, make the hitherto non-inclusive structures more porous, so that you see there are different viewpoints, and the same thing may not affect everyone in the same way, and therefore the law itself, you cannot. For instance, I'll give you a from India. Traditionally, a case is when family matters, matrimonial matters are filed, our women find it very difficult to go to the courts. And so an amendment was made that it could be filed where the woman resides, to take into account the difficulties that this is particular to my country maybe, but similar situations I'm sure are there in every country, and it is for the lawmakers to understand those difficulties of the disadvantaged groups, so that law itself becomes more inclusive. I mean, for want of a better word, I use the word inclusive. I mean, really equal.
Thank you. And there's a question for President Young. What can be done in the United States to make the legal system more inclusive?
Well, I think there are really two elements to addressing the issue. One is the easier of the two, which is to basically ensure that the laws are at least not preclusive. We have a long history in the United States of laws structured that actually are that exclude certain people from certain kind of benefits, and those fundamentally all have to change. That's probably the simple part. The second part, which is the more difficult part, is trying to have a better understanding of what it is that is preventing the inclusion. I mean, as you look at it from an educational perspective, if certain groups are underrepresented, why is that? Are there other kinds of structural challenges and barriers that are there, and how do you address those on a more granular level to make those opportunities not only equal in theory, but equal in fact? And that is That is a very different kind of enterprise, very difficult. And sometimes they're fairly crude ways of addressing that. And by crude, I mean sort of broad brush ways that cut with a pretty dull blade. But then there are much more sophisticated ways where you really begin to look and see what is it that actually prevents people from this community or this school district or this area or people with this background. Where are the challenges that make it so that even though these opportunities are theoretically available, they're not practically available? That's very heavy lifting and hard work, but absolutely essential to make any difference. Short of that, you just simply don't make a difference.
Thank you, sir. Anybody else who wants to react on that? Okay. The next question is that there seems to be a high level of unemployment amongst lawyers, both in the United States and in India. What can legal academia do to change this? And is there any, what is the reaction from the bench on this?
Actually, it might operate in different ways in these two different societies. We need to see how many people graduate from law schools. And recently, in the last decade or so, we have a bar examination which needs to be qualified, which a law graduate needs to qualify. Well, those who are able to qualify are a fairly high percentage. But having said that, it's also important to notice that the standards of legal education are asymmetric in the sense that I don't want to sound politically incorrect, but the learning content as well as what is learned, there is a great disparity between these two when those who qualify in these bar examinations do get into practice. Added to that is the phenomenon of, again being, might sound politically incorrect, the phenomenon of a few lawyers getting the maximum amount of litigation. Now, these are concerns which need to be addressed not merely by the bar and the bench. The bar needs to address it primarily, and at a social level, it needs to be addressed. If we see the way this has been addressed in other places, especially in the UK, the legal aid system has been very strong, and the legal aid lawyers have been also fairly competent and good. Now here, yes, they're stretched. The state has not sufficient capacity, and in some instances there is underfunding of many of these projects. Therefore, I think these challenges are huge, and one cannot visualize this being overcome immediately or in the near future. The added angle which gains more criticality today is the pandemic, and which has led to the closure of courts, near paralysis of the normal functioning of the courts, which has further added to the misery of the lawyers. As a member of the Supreme Court, I can say this, that we hear of stories which sadden all of us, and yet public safety and public health is important, so it's been not possible for the court to reopen in the normal sense, though the Indian Supreme Court and the High Courts and several courts in India have done really well, in the sense that there has been some form of access or the other. There has been no shutdown completely. Although we have, I don't think we can even quantify the extent of percentage of our functioning as compared to the normal. So I think the next few months are going to be bleak. I really don't have any answers, ready answers.
I suppose, oh, please.
There's something that I want to ask you. I've read some time ago that the American Bar Association insists on every lawyer doing certain number of hours pro bono. Is that right? That
Yes.
and every
Yes.
and how do they make sure that it is done? Because just now Justice Ravindra Bhat mentioned that few lawyers are very highly paid. If each such lawyer who is the expert or who's considered the top comes forward to do pro bono, I think that itself will change the temper of the legal sphere. And in an adversarial system like ours, very often it is the poor who suffers and who gets the wrong end of the legal decisions only because he cannot afford the best. He or
I can
she.
make one comment if you permit, just a thought which crossed my mind. The pandemic and the manner in which the courts have functioned has shown that those who can adapt to technology, and I'm not saying that those who are savvy or who have the best technologies, I don't mean that. Those who can adapt to the changing technology and make their submissions through virtual courts need not be necessarily the very well established or highly paid lawyers. Those who are direct, who are effective, and who can say what they have to say in the fewest possible words. I would again go back to the US and our National Law School mooting methods. Your ability to communicate most effectively in the least possible time is going to be very valuable in times to come, is my intuitive feeling. Therefore, this is itself going to perhaps open up and level the legal profession, and perhaps going to disrupt existing hierarchies, and is my intuitive and instinctive feeling.
Absolutely. President Young, did you want to say something? Yes.
Well, I just addressed this from sort of 2 points, I suppose. One is that we do have a higher unemployment level of lawyers coming out of law school than I think has been true. It does change over time. It goes back and it goes back and forth. I think the answer to that, we believe very much, I think, in the market, which is people get to choose whether they want to try and be something or not, and the market will determine whether they are successful at that or not. But I think for that to function effectively, there really needs to be transparency. And I think the law schools have a greater obligation than we have fulfilled so far in terms of really being candid about the nature of employment and of graduates out of our schools. And we're discouraged from doing that because there's some incentive to shade the data in terms of rankings of law schools and so forth. And I think there's not in our law school course, but in other law schools across the country, I think there's a tremendous lack of transparency. And so the students who might make informed judgments about whether they think this is an opportunity or not don't necessarily have the information to make that judgment. If that information were available, then the market would largely deal with it adequately. But let me go to a second issue. I think the issue, there's another fundamental issue underlying that, and that is not so much unemployment, it's a tremendous maldistribution of lawyers. If you are a rich corporation at the high end, you have no trouble getting good lawyers. And if you work in that sphere, employment opportunities are burgeoning, to be sure. But the cost of legal services for the middle class and indigent are frequently high, so high that they're sort of unavailable. And we have not figured out a way in which to allow people to effectively practice in those areas, earn a living, and nevertheless provide the services to those large swaths of America that have real trouble accessing adequate legal services. It's a little like doctors, the maldistribution of doctors in America, that we just don't have. We have too many doctors in the big city doing plastic surgery and not nearly enough doctors in rural areas and so forth. But it's very serious. And I just thought insight that there may be ways in which technology and other sorts of things would allow us to think about providing those services in a more efficient and effective way. That legal systems often stacked against those communities, and I think that is not entirely accidental. And we need to address that as well. But the problem, we have too many and too few lawyers in the United States, and that I think is that is a big part of our problem.
Thank you. Bobby, did you want to say something?
So no, I did think again, the employment market, obviously, again, as President Young suggested and as described, is what it is, and there's certain fluctuations that we see in it. I will say again, for me, that's a lot of that is how we think about what it is we want to accomplish. So what I always tell folks is that the need for lawyers in the United States, at least, remains massive. And I tell any lawyer, how many random people you meet say to you, hey, I got a problem with my employer, or I have a problem with my will, or I have a problem with my lease, or whatever else it is. There are massive unmet legal needs, as we've talked about. So the unemployment phenomenon, from my vantage, is a little bit of a market disconnect between where the opportunities that law students and law school graduates, lawyers are pursuing, and where the market needs are. Our task, because the question was about legal education, our task as a matter of legal education is to try and provide a legal education that is a matter of quality and cost, is enabling students to pursue that full range of opportunities and increase the level of alignment. Again, I don't want to talk about our law school narrowly, but I will say at our law school, that is among the things that we do very well at. We are trying to make our education incredibly cost effective while maintaining a high quality, because in that way, whether the person wants to go work for legal aid for a minimal wage, but provide important legal services, or they want to go and become an investment banker or do mergers and acquisitions work, we are setting them up for success in that regard. So that's, I think, what we are trying to do in the U.S. I think some law schools do it better and some law schools do it less well. But that's how I think about the connection of those two pieces.
Thank you. And this question comes from Live Law, which is one of the biggest blogs in India on legal issues. The question is, what will be the role of legal aid in the future in transforming the legal industry from the perspective of the judiciary as well as legal education?
Can I take that question? I think if we see technology can again play a huge role. We are talking of digitizing courts, and I think in a very broad sense there has to be a digital justice of the kind that Richard Susskind has spoken in his seminal books, which are very thought-provoking. So the courts traditionally are seen as physical spaces where litigants go to and get their disputes resolved. Now, with the kind of problems which the pandemic has thrown up, and the lack of access to societies and individual litigants, I think it's time that we revamped, at least technologically, our legal aid services, which can have a wider reach through the use of innovative use of these technologies. So in that sense, this pandemic can be really a game changer, and I foresee that in the near future, maybe a year or so, we could have very good web portals we have about 400 or so district legal services authorities. If these are activated, there's quite a possibility that people can direct their questions in the local language, get some answers, make informed choices, and seek the kind of remedy that they might want, which includes alternative dispute resolution. But I'll also hasten to add that technology itself should not become a barrier, and there should be the greatest caution while taking to this and switching over completely. It has to be done in a very careful manner. The motto here has to be to reach to the greatest number rather and ensure that there is no exclusion. So in that sense, I think we could be seeing an opportunity.
Ramanuj, Justice Sikri wants to talk. Thank you, sir. Thank you, Justice Bhat. I think Justice Sikri wants to say something. Can you unmute him?
Yeah, thank you very much for quite some time. I was muted. I was not able to participate. And I've been requesting. Anyway, no, I'll add to what Justice Bhatt has said and want to give a totally different dimension insofar as legal aid is concerned. And of course, in the context of technology and this COVID situation. Look, we have been using now technology because of this coronavirus to large extent. And today, hearings are only because of technology because these are virtual hearings. But it has thrown open another dimension, that is online dispute resolution, particularly when we talk of mediation, etc. as well, and pre-litigation mediation. Unlike United States, in India, to large extent, even today, mediation is court annex mediation, where the matter is already in the court, which is filed in the court, and the judge sends that matter for mediation. Now, but we want that pre-litigation mediation should also start in a big way, and before even the cases come to the system. And in this, what COVID-19 has taught us, that ODR, online dispute resolution, can play a big role. And there are certain kinds of cases, particularly cases of say even commercial matters, small matters, uh, this tenant matters, rent matters, etc., consumer matters. Now these can be decided online. When these are to be decided online and ODR, there even legal services authority can play a big role. In what way? Let me say that. Since if we want to encourage pre-litigation mediation and we want to encourage ODR, that is to online dispute, this we should provide some services to such people which may be marginalized or which may otherwise be a person who are not able to approach the court otherwise, because legal services authority and we have a act, and under that act this it is provided to certain kinds of persons with the, say you should have minimum this much of income, this income below this particular limit, or like to certain categories of persons including women, etc., irrespective of income, it is provided free. But why not, it should be extended to those who want to avail pre-litigation services, and why not they approach the legal services authority for that purpose, and if that is provided free to them, and coupled with that another aspect which is very important, because it is not only dispute resolution, we are talking of dispute avoidance as well. And if I may have a small dispute, but I think that I have a good dispute, why not the early neutral evaluation which is conducted, and the services are provided by legal aid lawyers through legal aid, and that those 400 districts which are in which legal services are there. If that can be done, I think we can achieve ODR, success in a big way, like it is happening in US, where more than 90% cases, 94-95% cases, they are settled at pre-litigation stage, and only 5% or 7% cases go to the court. And that situation is needed not only to take care of this, but to take care of our the arrears in the Indian courts as well. So therefore, in that way, what I feel is that legal aid in future can play a very big role.
Thank you very much, sir. And I do want to highlight, web analytics show that we've had a total of 631 people who logged in. Yes, so that's a wonderful number. I have another question, and this is from Madhusmita, and it says, is it possible to envisage a situation where virtual courts will exist parallelly along with physical courts after the lockdown period is over?
I just say a word about that. I have a son who is a federal prosecutor, and they are currently trying cases virtually. And I do think we will see a higher comfort level and in lots of different ways. Witnesses perhaps coming in virtually and other sorts of modifications that will be possible. I think we'll see it with arbitrations. I've done a great deal of arbitration work as well. The expense of flying back and forth, I think we will see changes across the board in that regard.
Thank you. That's wonderful. Anyone else who would want to react to that?
Yes, I would say this. I guess I would say that use of virtual court technology, electronic courts, side by side, alongside the traditional courts would increase. Probably we'll see the increased frequency of that. Of course, in many areas such as trying high crime, serious crimes, or complicated civil disputes where especially deposition is to be recorded, etc. Court hearings are necessary. But even in criminal proceedings, when you have to depose formal witnesses or the various intermediate motions which lead up to the trial, they can all be completed online. And likewise, a large number of civil claims and small petty criminal offenses which do not lead to prison sentences, we can adapt the hearings. There's a possibility of that. But then again, I would say that when it comes to India, looking at the numbers and the diverse population, the levels of education, and the problems of inclusiveness, it's always, we should not embrace it wholeheartedly and exclude include one and exclude the other altogether. You have to tread cautiously, and there's always the advantage and comfort of the look and feel of a physical court, where the litigant and feels the comfort of addressing a human being in a physical space. You mentioned, I think Justice Ravindra mentioned about family disputes. I must say this, that family disputes are seen as something typically a typical stereotype and a part of soft law. Well, according to me, nothing is farther from the truth, because that deals with human beings, and in many cases the lives of young infants, youngsters are at stake. So it's important and perhaps crucial that these are not, we don't take to technology wholeheartedly in these areas. In certain areas, very comfortably, we can completely switch over, for instance, taxation or the large number of commercial claims, except when some kind of technical evidence is necessary or where the parties want. So yes, certainly we can see this hybrid model going further, and that will probably transform the
Yes. If I may add to that, of course, I entirely agree with what Justice Bhat has said. And we are talking of hybrid model. Today, because of this technology, we have realized, and entire world has realized, if today that access to justice is also an essential service, and if we have to provide this service and we have to allow the courts to function, today we have no substitute but in a situation of lockdown, but to take the help of technology. Yes, at the same time, if we go back to normal times after a few months or maybe whatever, whenever, physical hearing and physical courts have their own advantages. So therefore, but at the same time, what this technology during this period has taught us, not only that it becomes indispensable today, which may not be the situation tomorrow, but it has many other advantages. In many respects, in many cases, it is many times adjournments which may be otherwise become necessary where the physical presence is not possible, but the case would not be adjourned, hearing still will still take place. It becomes in many cases more transparent, where the things can be recorded. And I tell you, in Indian context, when we are struggling with areas, as I said, uh, the technology may help us in time, this case management as well as court management. So more transparency, less cost. When we have all these advantages, my view is that even when we go back to normal times, we should not just discard this method. And here Justice Bhatt is sitting here, who knows it, because in Delhi High Court, almost 8 to 10 years ago, Justice Bhatt, if I'm right, we started with e-courts. So e-court, that technology was paperless court, and Justice Bhatt's was the first court which started as a e-court, and there today there are 10 to 12 e-courts in Delhi High Court. So therefore, that system still continues along with where it is, but that is a paperless court. But here we are talking of virtual hearing, that is video conferencing, along with this physical hearing. Wherever in all those cases which Justice Bhatt has mentioned, where physical hearing is indispensable, we have to go with that. But wherever we should segregate the cases, as he rightly said, wherever it is possible to have the cases settled through video conferencing or virtual hearing, we should utilize that technology for the benefits of it. And therefore, this hybrid model should go on according to me.
I may just add one small thought, and I've spoken about this earlier also. This COVID has taught that opportunities are hard to come by. Therefore, we have adapted to virtual courts. Now, there's a common request by lawyers that we should increase the number of hearings, we should possibly normalize it, etc. So, the greatest teaching of this virtual court has been that you have limited time. You have limited time to make your arguments. So therefore, supplement it with limited notes. We impose word limits, and we request lawyers to file this in advance. So the teaching which we would go back eventually when we restart the courts is that adopt this method and actually decide more cases. There's less for more, which means less time for more cases. Less time for each individual cases, and you start deciding more cases, eventually will actually ensure equality and greater access to justice.
That is why I didn't elaborate it, but that is what I meant with case management and court management. Yes.
Thank you very much. And the next question is, should we have some policy, both in India and in the United States, to accommodate recent graduates, the fresh graduates during the pandemic, to give them an opportunity to learn legal work? So how can both the ABA and the BCI help in this regard? So that's for both from an academic as well as a judicial perspective. Is there a way that we can help some of the recent graduates? I believe in the US we've already started doing that, but I'd like to hear from the panel.
I don't know what is being done in the US. That's quite an interesting thought to work on, but from the top of my mind, I can think that this is a good opportunity to do good by hiring young graduates at whatever levels, to the extent lawyers, and especially well-established lawyers, law firms, wherever they can, and even other lawyers, and ask them to prepare case notes in all those cases which are pending in their respective offices. And as far as corporate law firms are concerned, the workflows would be different, and the dynamics would be different. So in terms of law practice, I think this could be one way out. And as far as the system goes, I think this is also a case where every legal service authority, maybe every court, to the extent budgets permit, should hire young graduates, or at least involve them in projects which give them some kind of financial assistance, and at the same time train them for times to come to be more effective lawyers.
In one way, there would be need of young lawyers, particularly by those senior advocates, senior counsel, which you call Queen's Counsel, etc. Because at that age, today's age, when we need technology, we may not be that technologically savvy. And so youngsters can teach us that. So therefore, lawyers would be needing them in this perspective also. So therefore, there is a need of young lawyers today. At least they can guide insofar as technology is concerned, how to use the technology for using the court in so many ways. Because it is not only the virtual hearing like we Zoom, okay, you have sent me the link and I have been able to, join. But then in the courts today, filing is e-filing. Court fee payments are e-payments. When the some objection etc. is there and I have to remove that objection, everything is taking. It's computerized. It is online. So therefore, need of young lawyers who are technologically much savvy than the older ones, I think, would be much more in these days. So there can be a demand for them indirectly.
Thank you, sir. Bobby, do you want? Sorry.
Well, I thought I would just add a thought, but I'm not sure I entirely understand the question. If the question is recent graduates who just graduated from American law schools, the answer there is they are mostly studying for the bar examination right now across the United States. And so they are engaged in classes to be sure, but they're largely designed to pass the bar examination. If you're talking about, say, for example, college students who are just graduated and are we doing anything, I think mostly what we're doing is preparing for law schools to be relatively fully functioning by fall. And I don't know that there certainly will be some schools that will remain solely online, but I think most schools are planning at least some hybrid model of being large 50% in person and perhaps 50% online. But I don't know that work's going on in the summer to otherwise accelerate that, except on the modest level it's probably been going on before. But Bobby, you may know more about that.
I think that's exactly right in terms of graduates. The thing I would add is that I think the profession, from my observation here in the States, has been very responsive. I have lots of examples. We reached out to lots of employers, including judges, about opportunities for our students given the changing circumstances, virtual and the like. But my favorite response actually came from a judge, excuse me, who wrote back to say he wanted to think about an opportunity to bring in some additional interns, given the circumstance. And so we of course responded, that'd be great. We can find a student or two for you. He said, no. This is a federal judge here in Texas. He said, here's what I have in mind. I want to put together a set of 10, 15 kind of 1.5, 2 hour long sessions on different areas of legal practice and the like, federal law, presented by each of the judges on my court, each of the federal judges on my court. And then I want to bring the students in for a program that would basically be 50% observation of the process and 50% actually doing legal support work, drafting things and the like. And we said, oh, that's wonderful. I mean, that's a lot of work though for 1 or 2 students. He said, no, I want to do it for 30. So this judge is now bringing in 30 of our students as interns. Currently, I think they started this past Monday for this program that he created in response to the impacts of the coronavirus. So I think there are ways to be creative about this. And I will say, at least here in the States, we're seeing a very positive response from not just the bench, but from the lawyers and judges generally.
Thank you. And this will be the last question, after which we'll be ready to wind the panel up. The last question is, CLEs in India, do we need more continuing legal education, and how can foreign law schools play a role in it? And how will that help the profession?
Yes, I feel that continuing legal education is very necessary. Um, I remember personally about 14 years ago writing to the Chief Justice of India when I was a fairly junior judge. Uh, and we were given, very democratically, we were given a chance to write individual opinions along with the court's dossier, which was submitted to the Chief Justice's conference, and telling the Chief Justice that it is important that the lawyer community, the Bar Council especially, is is impressed upon this need for continuing legal education, at least for the efficient functioning of the courts. Otherwise, we would be always watching out for cases that would be overruled, and long-winded lawyers who would take their own time to come to the point with a barrage of case law which would be antiquated, and perhaps omitting the most relevant, which would leave the judge with far greater work. So I'm a great votary for continuing legal education. But then this is again a very uh, it's a topic that cannot be imposed. It's not a like entry to the bar. Uh, the the bar examination started only recently. The kind of continuing legal education, whether we should have refresher examinations or some kind of seminar attendance requirements, these are all issues to be debated and worked out by the Bar Council of India. But yes, I think it is essential.
You see,
The larger interest of the community.
realization has come that continuing legal education is necessary. Good thing is that Bar Council has taken some steps, but still not enough is done. So it's too late, too little. But there are some, in some law colleges, national law schools, and at some, like I remember just Mr. Venugopal, our present Attorney General, in his father's name, Nambias, started one continuing law education school in Kerala, where and gave to Professor Madhava Menon to run it. So I don't know what has happened after the unfortunate demise of Professor Madhava Menon few months ago. But otherwise, yes, the realization is there that it should go on for last number of years. But as Justice Ravi Bhat said, that not much has happened in this direction so far.
Absolutely. Continuing legal education for Indians, and I have this from an audience member as well, is an absolute must, and we should do that. With that, is there anything else that anyone wants to say from the panel?
Yes, if I may, I would, of course, this is not related to any topic. It's been a great experience being amongst all of you, and being asked to be part of the panel with Justice Sikri, Justice Srividhya Ragavan, who are all authorities, and Justice and Professor Young and Professor Roberts, who is I had the occasion to meet Professor Roberts when he visited India, along with Dr. Ragavan in January, and it's been nice being part of the panel. And I hope Professor Young also takes the opportunity of visiting India. I think you should come here and see, and not just interact with us virtually. You should come here, and when things are better and you're able to travel, you should come down to India. Thank you.
I should also thank, and I may also say the same thing, that I had the privilege of meeting Robert as well as Srividhya when they came to India, and it was really a nice meeting. I wanted to see Srividhya in a different avatar in India. I don't know when that will happen, but let us hope for the best. And thank you very much for organizing this and sharing, and at least watching you again, maybe on the screen. And let us, when the things normalized, and I love to hug you all in person.
Thank you.
Thank you very much. I repeat the thanks which Justice Bhatt and Justice Sikri have said. It's been a pleasure, and after months of isolation, it's lovely to see many faces. And I hope all the, I mean, apart from the 5 of us, no, 6 of us, I hope all the others enjoyed the discussion. You can convey it to Ramanuj, how much, whether you learned and if you enjoyed. But it's been a great pleasure, President Young, to meet you, and Mr. Ahdieh. We've just met over the email, so it's nice to see the face. Thank you very much.
I'd only add, all of you stay safe and stay healthy. All the best.
Yeah.
And may, if I may, on behalf of Texas A&M University, everybody from the United States who is watching this, express just genuine appreciation to all of our panelists. It has been extraordinarily interesting and insightful. You've given us a great deal of your time. It has been provided an exclamation point behind the need for American law schools and Americans to reach out even more broadly for these kinds of opportunities for interchange, and your generosity with your time is greatly appreciated. Thank you so much.
I would just add, sort of just very briefly, on behalf of the law school, it was a great honor and pleasure to host these distinguished, wonderful guests and to learn from them, for me as well. I hope, likewise, justices, we can have you to come visit us. This is Texas, and so when we invite justices to come, we generally invite them to come to a football game. So we will have to report back on the status of football in Texas as the coronavirus plays itself out. But we not only hope you can come visit for further intellectual exchange, but to come and see a game of American football as well. Thank you for participating.
Thank you.
Thank you, everybody. I do want to say, Bobby, that cricket is a little more interesting than American football.
Okay. Now, we talked about the things that unify us. I don't want to create division now.
Well, I just want to say that's certainly true at a certain level, but football has rules. It's just
President Young, I used to be a sports agent at one time, or an attorney for sports agent for cricketers at one time. So we should talk about the rules at some point. Well, thank you very much. It's been a great honor to have all of you. We've had 630, well, more than apparently people who have logged in, 34-ish people. Then I'm sure we wouldn't have had this participation if they did not enjoy it. So I'm grateful for the participation. I'm exceptionally grateful to each one of you for agreeing to speak, for agreeing to answer questions. Each of the justices, President Young, Dean Ahdieh, all of you, it's been an absolute pleasure to moderate this panel. And hopefully we can do this in person, either in New Delhi or in Dallas, Texas. So Dallas-Fort Worth, Texas. So I look forward to that moment. Thank you very much, and good evening and good morning, as the case is, to all for the rest of it.
Thank you.
Bye.
Bye. Oh, I forgot. Thanks for LawSikho for hosting it. LawSikho has taken a lot of effort. So before I forget, thanks a lot for Ramanuj and LawSikho to host the panel. Thank you.